Swayam Prabha. Digital India. Educated India.
So, friends, continuing our discussion on the Constitution of India and how it has brought about public administration in this country over the past 75 years of independence, uh, we would probably appreciate uh, the contribution of the Supreme Court and the High Courts, which are considered as constitutional courts, which are also considered the custodians of the principles of the Constitution. And the courts, through what we call as judicial activism, have been able to protect right to life in India. If you look at judicial activism vis-a-vis Article 21, one judge who stands out in terms of delivering the aspects of what right to life should mean was none other than Justice P.N. Bhagwati. Justice P.N. Bhagwati always wanted to expand the horizons of human rights. He believed that human rights cannot be static; it has to be dynamic. He also said that human rights must advance as growth, development, and the country progresses forward. He also believed in the moral and legal obligation of the judiciary to contribute to legal enlightenment, to remove the kind of darkness that can be there in democracies, and to light the lamp of justice. And for this, Justice B.N. Bhagwati always believed that the law of precedent means the law in which the judicial verdicts are respected. So, if the apex court or the top court of the Supreme Court lays down something, it should be followed by all the high courts. If something is said by the High Court, it should be followed by all the lower courts. So, the law of precedent and the common law, which is a law that is based on common sense, it is based on basic human rights tenets. These two, the precedent and the common law, can be the basis of judges to mold legal system and to give it shape and direction, because legal system requires a direction to progress forward, and legal systems only nurture that kind of a growth over a period of time. And I think the responsibility of the judiciary has been landmark in the country, especially in terms of trying to look at how law should progress forward and what should be the reading of law, and what kind of limits to public administration can be imposed by the judiciary. So the Supreme Court and the High Courts have an inherent constitutional power of what we call as the power of judicial review. Now, judicial review means, simply, friends, that the judiciary, in the exercise of its constitutional power as the custodian of the principles of the Constitution, shall ensure that the organs of the government, that are the two organs, the executive and the legislature, are within the confines and limits of what the Constitution empowers them. So, judicial review, I think, has been the touchstone of Indian democracy, and the judiciary has always been the protector of human rights. Uh, and hence, the judicial attitude in country in terms of human rights can very well be understood vis-a-vis how the judiciary has drawn the scope of Article 21, which says that which assumes a very positive right to life. We understand that Parliament is supreme, no doubt, in terms of laying the law, but it is a judiciary that is supreme in terms of interpreting the law and also holding the validity of the legislative actions as well. So, the constitutionality of every legislative and administrative action is to be tested by judicial review, as the case is. Now, we know that fundamental rights have always a special, kind of protection under the Constitution, and that's why they are so-called fundamental. They're just not mere legal, and hence, one would assume that suppose the courts looked at the right of delayed execution. Now, please note, in India, we still continue to have the practice of death penalty. There has been a lot of debate of trying to take this away. Uh, the courts at times, in the rarest of rare circumstances, this is the principle where the nature of the crime is so heinous that it shocks the conscience of the society, would grant not life imprisonment but a death sentence. And in India, death penalty is given by hanging. There are jurisdictions where death penalty is given by a lethal injection. There are jurisdictions in which other practices of death penalty are there, but we have continued to take the British practice of giving death penalty by hanging. Now, in India, the courts have said that if a man is under death penalty punishment, of course, you notice that there is a chance that the convict who has been sentenced to death can always file a mercy petition before the President of India. And the President of India will decide whether to accept the mercy petition. And if the case of acceptance is done, then the death penalty will be commuted to life imprisonment. So you will not be hanged, but you'll have to spend your entire life or rest of your life in jail. So sometimes you will notice that because of executive inaction, there is an inordinate delay in deciding these mercy petitions. And in those cases, the Supreme Court has found that it was most appropriate that such delay in deciding execution petitions must be protected under right to life, and hence the death penalty that is, pronounced to a convict must be commuted to life imprisonment. So that also is a case that has been decided under right to life, which means right to life under Article 21 is available not only to free citizens but can also be exercised by accused and convicts, as the case may be. Right to travel abroad, as we have seen in the Menaka Gandhi versus Union of India case, I think this has been very clearly laid down. You have the right to move freely across the territories of India, but even beyond the territories of India. So this kind of a right is there, subject to definitely restrictions that are there under the Constitution. But unless they are reasonable, unless they are laid down by procedure of law, then the right to travel abroad cannot be refrained or restricted. So you will notice that there are so many nations where this right is not there. It could be countries like China or North Korea and so on and so forth. So, the value of the constitutional principle, the value of the Indian judiciary can only be realized when you actually look at some of these rights. And you know that a lot of Indians are migrating to other countries to study, for work, and there is a huge Indian diaspora in almost all countries across the world. And right now, they are also assuming political and judicial offices in many of these countries, thanks to probably the case called Menaka Gandhi versus Union of India. I think that is one case that should get the credit of it, because the Supreme Court in that very clearly laid down that you cannot be stopped from going abroad unless the principles of natural justice are followed, or it is such a case that your passport cannot be issued, or there is an impounding as per the procedure established by law. So I think the philosophy of judicial decision has been very clear that there can be very less restriction or restraint on right to life, and this is something that can be positively enjoyed by Indian citizens under the principles of the Constitution. So any kind of restraint must be in public interest, and this would definitely give rise to a new dimension of rights, because you will notice just that word, three words, right to life, means so many other things. Right against bonded labor. I think this cruel, inhuman practice unfortunately continues in some parts of the country. Maybe whenever such an issue has come before the courts, they have abolished bonded labor, they have prohibited the same, they have taken criminal actions. There are legislations that actually make it a crime. But again, you can work, but you should work out of your own free will and choice. You cannot be subject or forced to do some kind of a labor. Right against custodial harassment. I think this is also important, that even if you're in jail and prison, you have the right of dignity, your rights of an accused. Any kind of custodial harassment can actually lead to a writ of habeas corpus, and the courts can actually intervene in these matters. So I think when you see some of these rights that are there in the slide, you will notice that in many cases, victims or aggrieved individuals have approached the courts for protection of their rights. They have approached the courts for recognition of their rights. But in many other cases, please note, many of these rights have been proclaimed by what I call as public interest litigations, or the concept of a PIL, where you are not seeking anything for yourself, but you are seeking something for a person who cannot probably access justice. And you will notice that public interest litigation also is called as social interest litigation, because you have a social cause, you don't have a private cause. It's not for something that you're doing. And public spirited individuals can now approach to the court for protecting someone else's right under Article 21 as well. Um, of course, right to emergency medical aid. Now, this was a very, very landmark intervention of the Supreme Court, because what used to happen before this right was proclaimed was that, if suppose there is a road accident and an individual is injured, it was considered as a police case, or kind of a case that has to be reported to the police immediately. The police may have to record the statement of the victim, and only then the doctors were allowed to actually give emergency aid. Now, whenever the doctors responded by giving first aid, emergency aid, trying to stabilize the patient because his life has to be protected first, these doctors were actually called to the court as witnesses, because they would have seen the patient, they would have seen the wound, they would have seen what is the status. So, to kind of educe evidence about the gravity of the accident before pinning of liability, the doctors would actually be called upon to the courts, and they were kind of feeling harassed by the system, because courts are not easy to be there. It takes a lot of time. The entire day may go. You may be called once or twice, and then you have spent entire your day doing the same, for having done what, a noble cause of saving life. Should you actually get the rigor of the legal system? So these were times when the judiciary decided to step in, and they proclaimed that there is right to emergency medical aid. And when such emergency medical aid is being provided, not in government hospitals, please note, government hospitals anyhow have the duty of giving treatment to every citizen, but this is about emergency aid being given even by private hospitals. So, Paschim Bengal Khet Mazdoor Samiti was a state of West Bengal, AR 1996 Supreme Court. Paramananda Qatar versus Union of India, AR 1989 Supreme Court. These were two cases that clearly established the fact that doctors have taken an oath, which is called the Hippocratic Oath, to save lives. And hence, they must save the lives, and the legal system should not harass them. They should not be called to the court to give witness. They should save lives first, and then the police can go about their investigation, as the case may be. So, I think these two cases, changed the dimension of the manner in which life was being treated by doctors, by hospitals, and by emergency aid workers. So I think that is also a very important, I must say, a very significant turning point about how right to life was protected in the Indian democratic system. Uh, right not to be driven out of a state. Now, this is also very important, because again, you will notice that the state where you can take birth need not be the state where you are employed, and where you're employed is not the necessary place where you will finally depart to heavens, or you will depart from this material world. So I think states in India should not create kind of issues of driving away non-state individuals. I think the territory of India is one union, it's one Bharat, and anyone can stay anywhere, vis-a-vis the rules that are laid down, of course. Of course, there may be some kind of restriction in certain tribal areas, in certain hilly areas, about whether you can buy land or not. That's a different issue. But I think you cannot be driven out of a state if you're employed in the same. Right to fair trial. Now, this is also important, because trial, even to a person who has been found guilty just before the trial also. So, you can't pronounce someone guilty before it. But let's assume in the Kasab case, where Kasab was found, with a AK-47 killing people, and there was videos that were taken out of him. So it was quite evident that he has to be held guilty for having caused the death of so many innocent individuals. Even then, Kasab was entitled to fair trial. After the trial, I'm sure he was pronounced guilty, and he was then executed through the death penalty process. Right of prisoners to have necessity of life. Of course, they should have life inside a prison. Right of women to be treated with decency and dignity. Of course, this is the principal rule of equality. uh, right against public hanging. You can't be, using all these cruel methods of doing public hanging, but this was quite an early practice during those days. Uh, of course, you have the right to be heard as well, and these were some of the rights that were there in 21. Now, does this end here? Not really. I think the new age rights under 21, read with Article 19 and 14, I told you, uh, all of these rights are in the golden triangle. The golden triangle is 21, 19, and 14. This is the triangle. So rights that are required for human existence and human development, the new age rights are under the golden triangle. For example, you have the right to information. Today we have a law called the Right to Information Act of 2005. It was read under Article 19(1)(a) under the freedom of speech and expression. You have the right to reputation, right of appeal from a judgment of conviction, right to social security and protection of family, right to economic and social justice, uh, yeah, to appropriate life insurance. All of these are, basically rights. You can't, do too much about it. Your right to sleep, because you can't be arrested in the midnight, and women cannot be arrested after 6 p.m. unless there is a critical kind of a threat that they may escape the provisions of law. Noise pollution, environment, and electricity. These are also new rights that have been recognized. Right to electricity now has become a very important right, because right to housing also has been recognized as a part of right to life. And go to right to education, which is something that has now come about under Article 21(a). Now, friends, right to education has been a matter of various judicial verdicts before this was brought about as a constitutional amendment under Article 21(a). So you will notice that right to education up to 14 years free education is now a fundamental right. The state government is responsible to provide this kind of a right, but the duty of the state to provide education has always been something that has been laid down by the courts from time to time. They have restricted, the so-called business of education. They wanted to know whether capitation fee management seats can be created, and the state, when it provides education, it should provide it with a social welfare purpose. So on education, I think the courts have been intervening from time to time, and I think they have been able to support the fact that right to education can be converted as an explicit right. Now it's enumerated in the constitution; it has been stated in the constitution, and you will notice that this now has been brought about, and so you will see that the Constitution 86th Amendment Act of 2002 brought this Article 21(a) into the Constitution. So I think uh, if one can read Article 21(a), it would mean something like this: that you have the right of education, which is free, it is compulsory, and it is safe. It also means that such kind of an education shall be quality education without discrimination on either the child's economic, social, or cultural backgrounds. So the courts have read Article 21 and what it means as a fundamental right as well. So bridging the gap between government schools and private schools, I think the right to education now is something that you have as a compulsory free education, irrespective of whether it's a government or a private school. Such a right shall exist under 21. So moving on to Article 22 of the Constitution of India. Article 22 of the Constitution of India uh, uh, gives protection against arrest and detention in certain cases. Uh, it says in 22.1 that no person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So these are certain safeguards that you see in Article 22 that are given to people who are arrested or detained. So they have the following rights. First, they have the right to be informed about the grounds of their arrest as soon as possible. They shall have the right to consult a lawyer of their own choice, and they shall be produced. This is in Article 22, subclause 2. They shall be produced before the nearest magistrate within a period of 24 hours of such arrest. However, in calculating these 24 hours, the time necessary for the journey from the place of arrest to the court of the magistrate can be excluded. Uh, However, no such person shall be detained in custody beyond the set period of 24 hours without the authority of a magistrate. So I think you will notice that Article 22 of the Constitution does give a very important safeguard, as it were, to people who are arrested. And this is an executive action. And so you will notice that the Constitution itself tells you the duties of public administration, especially the police, in the exercise of their powers, must follow the fundamental rights guaranteed to an accused or a convict under Article 22. Uh, what are these safeguards? These safeguards are based on the principles of natural justice that, of course, if there is any kind of an action that is going to be taken against you, you have to be told, informed. You have the right to be said about why an action against you is being taken. So I think it's just the fairness which we require under the principles of natural justice, the right to be informed. I think this kind of a right of a citizen and the duty of the state and its executive officers or the public servants, as we want to call, as I told you earlier, these are public servants. So they have to serve the public first. They have to inform the public if any adverse action is being taken against them. Now, this principles of natural justice, friends, is a principle of administrative law, is a principle of public administration. This has to be followed both in civil matters as well as in criminal matters. More so in criminal matters, because unless you follow the procedure established by law, you do not have the right to infringe someone else's right to life. So, informing the grounds of arrest is critical and important, so that, please note, the accused or the convict can make a rightful defense before the court of law. He can actually try and prove his innocence as well. So the reasons of the arrest are very clear, very important. They have to be communicated as soon as possible, and this will probably also ensure that any kind of arbitrary arrest or detention can be checked through judicial review. And hence, producing someone before a magistrate within 24 hours clearly means that the magistrate will apply his judicial mind in what we call as the checks and balance theory, right? You will check the police power, whether they have exercised the power appropriately. You will check it, whether it is so very essential to detain someone or can we grant him bail. As the Supreme Court has said, reiterated on numerous occasions, even now very recently, they've said right to bail must be granted in all bailable offences. They cannot be denied, and as far as possible, till you are held guilty, the police or the state must refrain from actually arresting you. So bail is the rule and jail is the exception, as the case is. So I think the police officer, uh, though have discretion sometimes in making an arrest, it's not a discretion that is subject of abuse and misuse. It can be checked, and the courts can intervene. Judicial mind can be made applicable on whether the arrest was necessary, whether the arrest is right, is there an evidence prima facie to establish that the accused has committed a crime. So all of these are important, and that's why a person who is arrested shall be produced before a magistrate within 24 hours. Um, Now, there are some exceptions in Article 22. So it says that, this clause 1 and 2, rather what we call Article 22, clause 1 and Article 22, clause 2, shall not apply to a person who, for the time being, is a enemy alien. Uh, so, someone who has been an enemy of the state, he's an alien, he's not a citizen. So it could be some kind of a spy from some other country. It's not an Indian citizen who's a spy. Indian citizen who's a spy can still claim Article 22, but someone who is an enemy alien. So alien means a non-citizen from an enemy state. Now, doesn't mean that every spy is from an enemy state. Unfortunately, Article 22 or the protection under Article 22 or the safeguard that is there will not be applicable to them. Preventive detention law also gives kind of it is an exception under Article 22. So preventive detention law is used in extremely rare circumstances where to maintain law and order, this law is invoked. The constitutionality of such law has always been a question mark. It's been challenged, but the Constitution says that this clause 1 and 2 shall not apply to any person who has been arrested or detained under any provision providing for preventive detention. Preventive detention is used against, say, notorious rowdies or those who are, habitual offenders. You are just kept detained. So it's preventive detention. It's not arrest. Just till everything calms down. It could be a house arrest. It could be a preventive arrest. So it's not necessarily that it's not on a ground or allegation that you have committed a crime. It is just that you should not be involved in the same. So to prevent you from getting involved in the crime, such kind of actions against people who have a criminal record can be exercised. And in those circumstances, if the preventive detention law is the basis of your arrest or detention, then the protection under Article 22 is not available. So Article 22 has 7 such clauses, and hence it gives you an idea of how meaningful and important arrest under the Indian Constitution is, and why should we look at the grounds of arrest as being informed, because only then you can test and check whether the grounds are fair, reasonable, so on and so forth. And please note, while Article 22 is an independent section, Article 22 is under the provision of right to life. So it actually promotes and supplements the right to life. So right to life of citizens includes the right of life under arrest and detention as well. Now, you will notice that sometimes we'll have to exercise the right of deportation of alien enemies, and in those circumstances, when deportation of some migrants or aliens are going to take place, then the provisions of Article 22 may not be applicable. Right? Okay. So there are a lot of cases and issues that are related to Article 22. For example, one being that suppose you have to be informed of the grounds of arrest, should documents regarding the grounds of arrest should also be given to you. Now, please note, while you can seek documents, it is not necessary that each and every document is going to be given to the accused, substantiating the grounds of arrest. I think what is important is many of these documents may be submitted to the magistrate as evidence, and hence, while documents are vital, it's not a rule that each and every document should be supplied, which can be considered as stating the grounds of arrest. However, the warrant, in case you have taken a warrant, must be issued, and the information must be mandatorily provided for, which can actually help someone come out of that kind of detention or as well. Of course, the right to be consulted is a very important right, and to be defended by a legal practitioner is so very important. This is mandatory, and please note, if someone cannot exercise the right to consult on his own, you will notice that we have established what is known as the Legal Services Authority. There is something called the National Legal Services Authority, state, then district. So anyone who has income less than a threshold, for example, in Karnataka, if the annual income is less than 1 lakh, you are automatically entitled to legal aid. So you can seek the state's help in getting your representation. And please note, such kind of a right of legal aid is under right to life. And you will notice that the right to legal aid, or what we call as the right to access to justice, is very, very important to ensure democratic values and to check abuse of the provisions of the constitution. So if one looks at the directive principles of state policy, that is part 4 of the constitution, one would notice that uh, yes, yeah. So you will notice that there are certain principles that the states must follow, and providing access to justice is one such state duty. Um, and So you will notice that the state particularly has this duty casted upon itself. And please refer to what is known as Article 39A of Part 4 of the Constitution of India. I have Article 39A with me. It says equal justice and free legal aid. So this is a constitutional mandate right now. It is the duty of the state to provide the same. And interestingly, you will notice that currently we have, the state legal services authority appoint lawyers as what is known as defense counsels. These lawyers have to defend those who are arrested and detained before the courts of law. That's their only job. They have to actually provide defense against state action or inactions. So that is their primary duty, and they're fully paid by the government. Like a government pays prosecutors to prosecute offences, here you have defense counsels who will actually argue against the prosecution and defend the arrested person or the detained person. So Article 39A, which provides equal justice and free legal aid, please note, was introduced by the Constitution 42nd Amendment in 1976. You will notice that 42nd Amendment in 1976 happens to be one of the major constitutional amendments that brought in several reforms, both in the enumeration of how the Constitution is written, but also in its interpretation, especially post emergency, how the judiciary started playing a very active role. 39A of the Constitution reads something like this. So let me just say it because it supplements Article 22. The state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity, and shall in particular provide legal aid by suitable legislations or by schemes or in any other way to ensure that the opportunities of securing justice are not denied to any citizen by reason of his or her economic or other disabilities. So, Article 39A is part of the Constitution, and you will notice that someone's access to the court and justice system shall not be deprived because of his economic or other any kind of disability conditions. Of course, the Kishananda Bharti case, which laid down the basic structure doctrine, is one of the landmark judgments in Indian history. Uh, as I told you earlier, it completed 50 years of this doctrine into the constitution, which means we should probably consider which are the basic features and structures of the constitution which cannot be amended at all or taken away. And I believe that Article 22 is one such basic structure as well. Uh, so, uh, so that's the Kishananda Bharti case for you. The Bennett Coleman case has already been discussed, so let's not repeat this case as we go forward. Right. I think going forward, we should come to Article 23 of the Constitution of India. And Article 23 of the Constitution of India deals with right against exploitation. Yeah. Article 23, right against exploitation. This article in the Constitution looks at prohibition of traffic in human beings and forced labor. So trafficking in human beings, or in vis-a-vis, trafficking, unfortunately, is a major criminal conduct, and you know that today trafficking happens across even borders. So poverty is misused. Poverty is the basic reason why there is so much of human migration, human exploitation, And the Constitution of India actually provides for some kind of a protection. It provides for state action against human trafficking, because there are so many forms of bonded labor. They can be quite modern, because the older bonded labors were with chain being attached. So slavery was one such notorious way of bonded labors. But there are so many other bonded labors that are created through the debt system. The zamindari system also created bonded labor. So there is a clear prohibition by the Constitution. The Constitution makes a statement that you cannot practice bonded labor and you cannot engage in human trafficking. And these are clearly prohibited under the Constitution. Actually, they need not be. It could be prohibited by any other law made by the Parliament. Of course, this is kind of a legislative prohibition or regulation. But keeping this in the Constitution clearly emphasizes the importance that the Constitution gives to certain values of respecting human beings and protecting human rights. So I think right against exploitation. Now, is that human right? Of course it is. What does right against exploitation mean? That you cannot be forced to work, and you cannot be bounded laborer for any reason, be it payment of debt or some kind of obligation that you owe towards the individual. So no such form can be permitted or allowed. And of course, human trafficking, which means that you cannot use human beings for your own selfish interest. Either, for example, you can't employ a beggar to beg for you. That would also amount to some kind of human trafficking. Engaging sex workers and trying to gain a living from the fact of the sex worker is also one form of human trafficking. So, the state ought to give equal opportunity of employment to every individual without any discrimination based on any religion, race, caste, or classes as they were. So I think that is very important for the state to practice. And I think engaging children in labor, I think it's important that you realize that the Supreme Court has been protecting the rights of the child. Apart from, there are so many international conventions to which India is a party, the notable ones being the Convention on the Rights of the Child. But, if you see how the Supreme Court has intervened on child labor, I think it has actually done a kind of a very noble service in protecting child rights in this country. Through several cases, including the most popular case is called the Bandhu Mukti Morcha versus Union of India. It's a 1997 Supreme Court judgment. I think the courts have clearly said that the states must enact legislations that clearly prohibit child labor. Uh, so, children have only the right to education, and employing such kind of children is an offense. And please note, we used to say that the health of the child is the duty of the state. So initially, you would notice that under some of these legislation, children were not allowed to work in hazardous industries. Who is a child? Anyone less than 18 years is a child. But please note, between 14 and 18, you can be employed, but in a non-hazardous industry. So between 14 and 18, certain conditions, children can work. You can be a startup entrepreneur. You can employ people. You can actually work in your own farm, in your own house. But you should not work in a hazardous industry or in a capacity where your health is impacted or your innocence is exploited by any chance. So the Supreme Court has given a lot of directions on education, health, and nutrition of child or children, as the case is. And I think that has been a very significant part of Article 23 of the Constitution. Now, employing children as prostitutes or sex workers has also come to the purview of the Supreme Court through a lot of public interest litigations. And I think under Article 23, the Supreme Court has very clearly, shown the path of, treating this as a very serious and heinous crime of pushing children into sex trade or sex workers. And interestingly, it's not only children of India, but even those who are coming across the border. I think the Supreme Court has very clearly, had very less patience regarding all of these. Of course, we had the Devdasi system, And in Vishal Jeet versus Union of India, a 1990 Supreme Court judgment, I think the Devdasi system was also reviewed by the Supreme Court, and the Supreme Court did not approve of these kinds of systems that actually bring down the modesty of women, dignity of women, and don't treat them equal under the justice doctrine or justice idea of the Constitution of India. Article 24 is similar to Article 23, it's right against exploitation, but it's very specific in terms of saying that there is prohibition on the employment of children in factories, because factories are considered inherently some kind of an hazardous activity. So you cannot employ any child. But please note, it is only the prohibition is up to 14 years. So after 14, you can probably, based on certain kinds of industries, uh, but again, you will notice that there is a clear prohibition of employing children in mines. So even 14 to 18 mines are considered as hazardous. Factories are considered as hazardous. Um, Yet you will notice that some of the term what is hazardous has been a kind of a challenge, because in some cases you will notice that whether a construction industry is hazardous or not. Uh, I believe it is hazardous. The Supreme Court has visited this. Sometimes they have come to the conclusion that construction industry may not be, but use of cement, construction industry can actually impact safety of the workers. So I think state governments have passed regulations on prohibition of children in construction workers as well.